She does appear to be because I've heard
All right, this is a matter of the city of, or the state of Michigan versus Mazie Lumia, 2442.
Good morning, Your Honor. Christopher Sheffield, appearing with my client approaches.
Ma'am, your name for the record, please.
Macy Lumia,
Okay, and so why, is that your children with you?
that's my daughter with me.
Okay, you didn't have anybody that could watch it today?
No, I had asked my sister, she left this morning before I got up. She was supposed to watch it, but didn't show up.
All right, and do we know is, where's my sheet? Kevin, did you look at this file today?
I did, Your Honor. Well, I did not look at that file. The PSI was emailed to me from probation, so I reviewed it on probation.
Okay, all right. And so, today's the date scheduled for sentencing on your client's plea to an amended charge. Your client received a great deal, and this matter, this larceny by conversion was amended to an attempted larceny by conversion. And did you have an opportunity to review the report and recommendation with your client?
Yes, Your Honor, it's factually accurate.
And is Alexa Smith in the courtroom? Okay, she did send in communication with probation regarding the clothing that has now been lost to your client. And there are not any corrections that need to be made?
Your Honor, I saw that there was a restitution amount. My client has indicated that restitution has been made in regards to this matter.
And how much was the restitution that you paid, ma'am?
$97.
$97?
Correct.
When did you make that payment? And to whom did you make that payment?
It was disputed through PayPal, so my PayPal is on negative because she disputed it through that way. And that was possibly, so I think this incident occurred in October of 2021. November, I was supposed to have the shirts, sweaters done before December of Christmas. I want to say it was probably a little bit afterwards.
Okay, so she's claiming the restitution amount is $282, and that the items that she gave to you for whatever you were supposed to be doing, making a blanket or something?
It was a sweatshirt out of baby onesies.
Right, those are keepsakes, and she doesn't have those back anymore either.
Right, so
Where are the items?
I had placed them on, I told her, I had been to her house one time when it was raining, and she lives in Wyandotte, I can't remember the exact address. So when we were in communication and she had kind of helped with my sisters and my family, I let her know I was dropping them off on the porch. Clearly the address was, it was like something around 5, so I mixed up the two numbers, but I did place the address, or the bag of clothing on the wrong porch apparently. Cause I couldn't get this sweatshirts done okay.
All right, counsel, as to the recommendation.
Your Honor, I'd ask you to consider the amount of time that's gone by since this date of the offense, and in the meantime, Judge, my client has been gainfully employed. She's been there for over 8 months as a sales rep. She's currently living in Riverview with her 3-year-old daughter. She is a single mother. She graduated high school in 2010, and she went to college with South University. Your Honor, in the circumstance, I'd ask you to consider the consequences she's experienced while on bond. She had to post a $1,000 bond. She did 13 days in jail. She's been on a tether since September 12th. She is still on a tether. Judge, I believe that she has been admonished for the poor choices she made. I'd ask that she be admonished no further than costs and fines with no probation and no jail. Thank you, Judge.
Well, here's the thing. So Ms. Lumia does not seem to learn from her mistakes. She has a retail fraud in 2014 in Southgate, a retail fraud out of Woodhaven in 2016, and then another retail fraud out of Flat Rock in 2016. And then there was a trespass out of Riverview. Was that also a larceny matter or something that was amended to trespass?
I don't know if it was amended to trespassing, but there was a trespassing.
Right, was there also larceny or something else?
They accused me of stealing a $3 shot glass.
So ma'am, you seem to have a problem with,
Making the choices.
what's that?
With making the correct choices and following through, and that's.
And Judge, I'd ask in this situation for myself to allocate opposed to my client. Judge, I'd ask you to look at the dates and the years on that. My client now has a 3-year-old daughter, and I believe that she was making terrible choices before her daughter was made. And based on the fact that there have been no new charges in the past 3.5 years, I think that is directly correlated with her new responsibilities. And I'm glad to see that we're not here arguing 2021, 22, 23, and 24 cases. She's very apologetic, but it does appear that she has put her right foot forward, and she is making better life choices. And the amount of admonishment that she's received on bond does seem relatively intense, and I think that is based on her prior actions. But I am very grateful to see that she is not continuing these behaviors. Nothing further from me.
Okay, except for in October of 23, when she communicated with Ms. Smith to make this sweatshirt of some sort, and she didn't make it. She took the items of Ms. Smith, which she had been saving that were keepsakes, and she didn't do what she was paid to do. And then also, your client was given an opportunity to make it right before charges were filed. And she didn't do that. She didn't do that. And so I'm not sure, ma'am, I mean, you had over a year to make a sweatshirt. You advertised that you could make this sweatshirt. Somebody paid you the money. Somebody gave you clothing that they had been keeping of their child's. She gave you that clothing so that you could make this sweatshirt. And you didn't do it. You didn't do it. And then you didn't intend to do it because you deleted your social media. So you couldn't be contacted. And when you were given the opportunity to make it right, you didn't do it. You didn't do it. You could have avoided these charges because you were in communication with the detective. And they gave you a deadline, you didn't meet it, and then they submitted the warrant.
My client does have a response.
So, I understand where I was wrong in not completing it. We actually went to Catholic school together, which makes it gonna feel guilty even longer, but, so we knew similar people when I worked at Cornell Ford at the car dealership. We both knew someone in contact with a police officer that works at Wyandotte. I had people from Cornell Ford calling me in regards to the matter, the posting on social media. I just felt very guilty, overwhelmed with the situation. I didn't want it, like I was in the process of trying to get my job back at Cornell. They had let me go because after I had the baby, the scheduling wasn't lined up with having a child. And I understand like in 2021, after I had my daughter, I had terrible postpartum. I didn't have the correct mindset and I lost my job at Cornell Ford. And then once I had Ricky Ermon and everyone, Darren Crowell, everyone was contacting me in regards to the matter, I just felt like ashamed of what I did and I didn't know how to resolve the matter moving forward, to be honest with you.
Okay, and so ma'am, I hear all that from you.
Right.
But now you have a victim in this matter who gave you clothing that she was keeping as keepsakes of her infant.
Right.
And she asked you to make a sweatshirt out of that clothing. So now she doesn't have the clothing, she doesn't have the sweatshirt, and she had to dispute the payment because you didn't do as you were supposed to do. So you didn't actually refund the payment to her, she disputed it.
Right.
And I mean, it doesn't appear as though you've learned from any of your choices that you've made previously.
I have to correct you on that one. I do feel like I have learned. And I know my record is like ultimately the worst thing in the world. I have a 12-year-old daughter at the time, my mother, and then fought to get custody of my oldest daughter. So there was a lot I was going through in the process of why I made the poor decisions I made. Now I'm at a point where like I'm in sales and like having the tether on me, it's embarrassing. I'm embarrassed of myself. I have to be confident in sales and I'm not. I have to explain to my 2-year-old daughter it's an ankle, but she don't know what it is, and then I have to hide it from my 12-year-old daughter, my family, everybody, nobody knows I have one on. So and then even when I went to jail for the 12 days or 13 days I went, I pretended like I was in a sales conference, like lying to people I know because I'm embarrassed of my decisions and my past of what I made. And that to me is where I feel like I have learned, especially this time around. In the past, maybe you could say I have not.
Okay, but but you're not even taking accountability. You're lying to people. You're lying to people as to what is going on right now.
No,
You're lying
about
to
the
people as to, that's the teller, as to where you were when you were in custody. I mean, why not own it? If you were to own it and show your accountability,
Right,
that would tell the court that you have accepted responsibility.
right.
But you haven't, because you're continuing to be dishonest. Your criminal history is littered with crimes of theft or dishonesty.
Right. And I feel like, I'm not being dishonest with the court about my actions. It's my mother, after my dad died 3 years ago, my mom's a mess. So she doesn't need the responsibility of what my actions were and what I did wrong. On top of that, I wasn't really raised with my mother in their household. I was on my own when I was 17, 18 years old. So it's not that, like her dad knows, he helped me get out of jail, he helped call the time. So I'm honest with the people that are in my circle and my family as far as her father and my daughter and my little one, because she's seen it. But like my oldest one is at my mother's household, and that's where I feel like I don't want her to look at me as such a bad role model, and that's where I meant by saying hiding it.
And so I show that you posted bond on September 10th.
Correct.
And then how long were you waiting for the tether?
It was around 13 days.
You waited for the tether for 13 more days?
Correct. So the bond was posted here while I was incarcerated, and then I was shipped to county to get the tether, and I was waiting that process for the tether. I got in there Friday, I stayed 2 Fridays, I got it on the following Monday.
All right, here's what the court's going to do. The court finds after reviewing the report, the recommendation, hearing from counsel, hearing from Ms. Lumia, and reviewing the criminal history and the report, and taking into account the communication from the victim in this matter, does not find that there's reasonable grounds to Department of CL 769.5. And according to Ms. Smith, she states that the items of clothing were not returned, neither was the money. And so, and she didn't have any receipts regarding the clothing because they had been kept for keepsakes, and so obviously it had been a few years. So, the court is going to order 45 days jail, credit for 13, and the court's going to, so that's an additional, let's see here, 32 days that this court's going to have you serve. The court's going to suspend 25 days, so you're going to serve 7 days.
In your honor, as to the time in custody, we appreciate the suspended days. Would it be possible for my client to have a report day or a report time? I know that she has her daughter here today. She just needs to make the necessary arrangements. She's not failed to appear at any court dates. I have no reason to believe that she would not appear timely, especially with what I'm sure is to be followed if granted the penalty of failing to appear.
Yes, I will have you report December 26th.
Yes. Can you do that? Yes, Your Honor. Thank you for that consideration.
Of course, I have to start off in mute, so that's how that works. Hey, everybody, welcome to American Courts. Thank you for coming to the show. It's been a little while. We've been out and about. Shane, we got some soft set coming up next, so just hang on a second there. Thank you all for coming out. A pile of people in here today. Got a whole bunch of people. Big and Raid, thank you so much, Big, and we always appreciate you coming over and sending folks over here. Nancy can't hear me. Nancy can hear me now, so she can hear me now. So we're going to do that. Yep, absolutely. I forgot to unmute my mic. That's just how I roll here. We got Judge Middleton, we got Debbie Davis making an argument, and we got quite a few different courts today. Let's see which one. Let's go to the sovereign citizen in Thurston County. So let's see where that.
So, Mr. Valentine, would you unmute, join us, or I should, if I remember correctly, you'd like to be referred to as American National Valentine?
Present.
Okay, and is that how you'd like me to refer to you?
Yes, ma'am.
Okay, I don't remember that. So, sir, there was a warrant issued for your arrest back December 6th. You had posted bond on the previous warrant. We had a hearing, and that's what we're here about, is we're still pending trial. And you weren't, the pretrial services violation, that's right. We've got a positive UA from November 1st for THC and cocaine, November 20th, a dilute one, but concerned about THC and cocaine, November 22nd, a UA positive for cocaine. So that's why we're here today. And I remember in the past that you were representing yourself. Is that still your intention?
Yes.
Okay. So let me turn to the status to this warrant issue, and then I'll turn back to you. And Mr. Weston?
Your Honor, this time the state would be asking that the current bail be increased to $10,000. It was previously, the state previously asked that amount at arraignment. The court previously imposed $15,000. That somewhere throughout the process, the court decreased the bail to $5,000. He posted the bond for that amount, and which I believe he was released on October 29th. And within a month, we have all these pretrial violations. And so the state has substantial concerns about him not following the release conditions that he's required to follow, especially being on pretrial release for DUI. And so the state's asking that the court impose $10,000 bail at this time, and that he either posted or turned himself in.
So, Mr. Valentine?
So I object the state motion. The release conditions that were set were not returned. Ooh.
I can hear you. I can.
Okay. Yeah, the release conditions that were set were not returned to its original state. The release conditions were only changed because the 3 charges were added. And once the 3 charges were dismissed, our release conditions were supposed to be returned to personal recognizance. There was other individuals when I was in custody that were in the same situation. The state brought charges against them, but the state didn't have the physical evidence yet, and they released those individuals on their personal recognizance and waited for the results, for the evidence to pursue those charges. But with me, the state is being prejudiced and tried to keep me with strict release conditions, even though the charges were dismissed.
I'll come back to you, Mr. Valentine, but let me ask that particular question of the state here. So is the state ready to go forward to trial? You have all the evidence, all the discovery on this matter, or is there toxicology reports that are pending, or?
Based on my knowledge, Your Honor, there's no blood draw in this case. The state is ready to proceed. It was American National Valentine that did request the continuance of trial confirmation on 11/8.
So you've got everything. You're
Yeah,
not
we got
waiting for
everything.
intox reports. Okay. All right. So back to you, Mr. Valentine. Anything else? Or I'm sorry, American
Yes.
National Valentine.
The state was awaiting the toxicology report for case number 4A0027328. Those 3 charges that were added on to the case was the reason why I was in on the ankle monitor and working with friendship services. And so since those charges were dropped, I'm only on the case for my DUI, my first DUI. I never had any previous DUIs. This is my first DUI. I was only brought into custody for the extra charges that were added on, and those charges were dismissed. But the release conditions were never changed.
So
Even my
this
bail,
one-
they didn't even lower the bail. I had to argue with the court just to get the bail lowered, even though the charges were dismissed.
So this one is alleged from November 13th of 2021. And then I see that there was a January 1st of 2024 that was dismissed. And now it looks like that has been refiled with an arraignment date scheduled for January 14th. Don't know if you've gotten that in the mail yet
Yes,
or
I
not.
have. Yes, I
Okay,
have.
so, all right, so you're right. These conditions are only about the case alleged from November 13th of 2021. Gotcha. All right. And that's the court order on that matter. 1A730693 was the pretrial services requirement and the requirement of sobriety. All right. So you're saying that, and tell me if I'm wrong, you're saying that I should release you, set this on for trial, and what about conditions of release?
So the conditions to release, I should be back PR'd as I originally was with this charge. If on the other case, like how you said the case was refiled, it's going to be in January. If the state wants to set, release conditions for that charge, that should be done on that case. But they're two separate cases now.
All right.
Does that make sense?
Yep, it does. And there was, all right. I guess I don't agree with you. There was a request to October 28th to change the release conditions, and that was denied. I guess that was me from the court's docket. That's what I'm reading. And so that was considered already, and that was denied. So, and now I have these allegations from pretrial services. So, all right, Mr. Valentine, we've had difficulty with getting compliance while you're on release. We've had difficulty with getting into court. And so I am going to increase that bail amount because 5,000 apparently isn't working. And I don't know what else to do. Pretrial services supervision isn't working. And so at this stage, a 10,000 cash or bond bail needs to be posted. You're appearing on Zoom. So either post that 10,000 cash or bond bail by Friday at 3, or you're in custody by Friday at 3. So you make that decision. And then we'll have a hearing I'm going to set this, where are we? I'm just going to set everything for that January 14 day. And so that we've got everything together. What time that is, but you either, as I said, 10,000 cash or bond bail to be posted no later than 3 o'clock on Friday the 20th, or you're in custody by Friday the 20th at 3, no later than 3. But we'll set this hearing. The next hearing will be January 14th at 2:30. It's a pretrial. So, any questions about your obligation there?
Yes. What are the nature and cause of these charges?
Driving under the influence. You're charged with and driving while spending the 3rd degree. The complaints are in the court file.
And what is the criminal jurisdiction like? What's the nature of the causes? Is it
Nature of
under
the cause.
admiralty jurisdiction or common law jurisdiction?
Washington State, RCW 4661. Violation of the state law. You're in Thurston County District Court, which has jurisdiction over you, as it's alleged to have occurred in Thurston County.
But I'm asking, what's the nature and cause of the charge? Is it under a
That's what I'm
common
telling
law?
you.
Is it
No,
under
it's under
common law
RCW
or admiralty?
4661. It's under Washington
So-
state law.
Don't you
Washington
have the
state-
duty to make the nature and cause clear to me, ma'am?
I
Do I
have,
not have a right to know the nature of the cause?
yeah,
nature and
and I
cause?
have. And you can put it to writing if you think there's something more. A bill of particulars might be something that would be useful to you to send to the prosecuting attorney's office. But
I requested
That's what I've
a
told
bill
you
of
today.
I've requested a bill of particulars and I've requested the case transcript and I've gotten neither.
yeah, it's not going to be transferred. There's nowhere to transfer it. You're in the correct jurisdiction. You're in
I said
Thurston
a
County
case,
District Court.
I said I asked for a case transcript and a bill of,
Transcript,
yeah,
that's not
case
okay.
transcript and a bill of particulars, and I still
Okay.
haven't gotten it.
All right, we'll follow that up with the prosecuting attorney for the bill of particulars and then the transcript. That would be from the court if you wanted an audio recording of the proceedings. All right,
Still
so,
haven't made clear the nature and cause of the charges, ma'am.
all right, well, I think I have. So you're to turn yourself in to Thurston County Corrections no later than tomorrow by 3 p.m. or you can post 10,000 cash or bond. We'll have our next hearing January 14th, 2:30. And you stay clean and sober and law abiding, and you're still on pretrial services supervision if you're out of custody and you comply with them.
So is the prosecution under common law or under admiralty?
We're not going to go in circles here. You have
I'm
an
just asking you
obligation to
to, I'm
be,
just asking you,
I
as
understand,
my
I've
right, is it
answered.
not my right to know the nature and cause of the charges?
I've answered you,
so-
Mr.
so which
Valentine.
one-
I'm not going to go in circles. You're in custody by Friday, or post 10,000 cash or bond. We'll see you January 14th. That's all for today.
So why can't we go back to the original release conditions?
I've already made that ruling, sir.
And it was a void ruling, it's a void judgment.
So long, Mr. Valentine. We've talked. Be in custody by Friday or post your 10,000 cash or bond. We're done here.
So you're not gonna honor your oath to
We're
uphold
done,
the
Mr.
Constitution?
Valentine. I'm honoring my oath and I've done exactly what I'm to do by state law and constitution.
You haven't made
simply
clear the
disagree.
nature, you haven't
We're
made
done,
clear the
Mr.
nature and cause of the
Valentine.
charges, ma'am.
Please mute Mr. Valentine. I don't want him to say something that would be untoward for him. So we're done, Mr.
So she got done with him. I really want to see one of these sovereign citizens win. I think it'd be interesting to see. I've seen a few YouTube videos where it talks about them winning, and it ends up being a technicality or something ridiculous on why they won. I didn't catch that his last name was Valentine. I was trying to figure out how he come up with that title of Valentine, and then I caught on to it being his last name. I'm not the quickest sometimes. Sometimes it takes me a minute. And as I said that, I looked over to make sure my microphone wasn't muted. So we'll be happy there. Thank you everybody again for coming out. I'm noticing Nan isn't there, so we're gonna have to say something to Nan. She's probably causing chaos in Nashville somewhere. So it's Friday night, so she's probably raising hell down there. So let's look over to Judge Simpson. Let's see what he got going on.
Your name, sir?
Jonathan DeHaye.
All right. Go ahead. Now. What are we doing?
Yeah, there was a matter of a bond violation that was issued. Apparently, my client presented himself on November the 27th. We appeared before the magistrate. He was arraigned on the warrant. There were certain bond conditions that were set, one of which was to check in with community corrections and register. He was also to enroll in a drug testing program. Apparently, there was some confusion about the community corrections contact portion, but he did enroll in a drug testing program. He was allowed to test in Macomb County where he lives, and but apparently did not.
Who allowed him to test in Macomb?
I'm sorry. I didn't hear you, Judge. I'm sorry.
Who allowed him to test in Macomb?
That was the magistrate indicated that at the time of the arraignment. She said he made a test in Macomb County.
He testing.
He enrolled at a place called Adapt in the city of Warren, and he did.
Do we have any results?
He submitted the one test there. I don't have any results, but I did have verification from the place that he did in fact sign up for testing there. Once it was brought to our attention that he had failed to contact community corrections, he did then call community corrections to try to enroll. They told him because the matter was in warrant status, they couldn't address it. We'd have to deal with the court. He turned himself in for immediately or shortly after finding out about this. He presented himself last week to the jail and was told that he'd have to address the issue today because today was his court date for probable cause conference. So I don't think there was any part on Mr. DeHaye's part to not comply. It was just a matter of some confusion on his part about contacting and meeting with community corrections directly. I think he is 32 years of age. He is working, steadily working. He does have a young child he supports. As I say, he did voluntarily appear both.
Does somebody have the test result? Where he's testing? He didn't do anything. He didn't go for intake, nothing.
I went to,
He didn't
My
go
last
to
week, Your Honor.
the but he did enroll in a testing program. And he did attempt to make an appointment to go to community corrections, but the matter was already in warrant status. So he did appear, as I said, voluntarily, both in November and in December on learning of this warrant. So he's not, I don't think he's trying to deliberately avoid any responsibility, Your Honor. And if given the opportunity, I do think he would comply. He does have counsel. He is anxious to address this matter. He asked the court to consider reinstating his bond. Thank you.
Landy, before you explode.
Thank you
Yes.
so much, Your Honor. Your Honor, the people are going to request that the court review the bond decision made by the magistrate in this case and find an abuse of discretion. The facts alleged in this case are, first of all, that this is an OWI third offense.
Can I just say, you're
Yeah.
saying on the original one? Go ahead.
Yes, the original one, but I understand the bond has been denied right now, but the conditions ordered by the magistrate, the people appeal were an abuse of discretion and were not sufficient to ensure public safety. This is an alleged OWI third offense with an alcohol BAC of 0.120, cocaine and THC were also present in the defendant's system. I think if I didn't already say, there was a crash, and his priors are from 2017 and 2021. People would request that he have at least intermediate, if not strict supervision from community corrections, as well as an alcohol test in place prior to any release.
Anything else, counsel?
Well,
I mean, is he in a treatment program? Or is he just testing?
it was just testing. That was all he was ordered to do at the time of the arraignment on the November the 27th. And he's working. He supports a young child. He's, as I say, he turned himself in, not only on the original warrant, but he turned himself in voluntarily as soon as he found out that this was, there was a violation. He immediately turned himself in. And the communication that I received from the court was either he has to turn himself in or they'll address it at the time of the probable cause conference, which was today. He turned himself in as soon as he could, which was turned out to be last week, and he's been in jail for the last 6 days. So I don't think there's any attempt on his part to try to avoid his responsibilities here.
Right, but counsel, I'm not clear how we got a PR out of the gate if the allegations are even near true.
Well, he is charged with an OUIL 3. That is true. That was known to the magistrate at the time. We presented information about his background, as I've done here today. And the magistrate's the one that set the bond conditions. So I'm not sure. There was nothing unusual about the case, that there was no injury involved in the case. It is still just the 5-year max. So I don't think there was anything that the magistrate was not aware of under the circumstances, certainly from the face of the file or any additional information. As I say, we provided his background information, which I restated here today. So he is employed, and has been for some time, and he has.
Okay, so first of all, let's back up a second. I don't have any results from any testing that he has allegedly done. Let's make that clear. You're telling me that I don't have anything. I mean, from this side, counsel, understand, this looks like he didn't go to community corrections, hasn't tested, hasn't done anything.
Well, I don't disagree with that, except that he did contact community corrections after the matter was in warrant status and attempted to get enrolled with them, and they told him they were not able to process him because the matter was in warrant status. He also voluntarily appeared, he didn't wait till today's date. He came in early to present himself to try to address the situation early. And they said because there was no bond that was issued with the order that he had to sit there, and has sat there for 6 days. So he has obviously suffered some penalty.
Where are the test results?
Your Honor, I don't have them with me. I
I'll
don't
tell you
have
what,
test results.
before I do anything, because you're just going around in circles. You're telling me all of this stuff, but it doesn't make any sense to me because I don't have any test results. You're telling me he contacted community corrections after he's in bench warrant status. I have someone that's obviously a user. I don't have any testing whatsoever. Never reporting to community corrections. In my opinion, that poses a danger to the public because I don't know what he's doing. He's not in any treatment. He's not in anything.
Well,
So I'll give him a bond.
doesn't the file reflect that he was allowed to test in Macomb County? Because she put that on the record, the magistrate did.
But I don't have the results.
I
Follow
understand.
me here.
I
He
understand.
still would have to go to community corrections. He could test then in Macomb County. He has to sign a release. Those results get sent to us. I don't have any of that.
Understood. I'm simply asking, would the court allow him to be discharged, be released on a bond? He can report to community corrections before he's released from
Tell you what I'll
jail.
do. Because I honestly, counsel, you're not hearing me. So maybe somebody can figure it out. I'll set his bond at this point. I'll give him a bond. I think he's entitled to a bond now that he's appeared, albeit however he's appearing. I'll set his bond at 50,000 cash surety. I'll consider looking at that if somebody can provide me test results and I can set adequate conditions in regard to his supervision. But other than that, I'm not doing anything else.
Your Honor,
Yes, Ms. Lundy.
could the court consider at least a 10% provision on that bond? I mean,
What? What?
would the court consider at least a 10% provision or something? Maybe.
No. You're just not following this at all.
I'm following that he went from a personal bond to now a $50,000 cash surety bond. And I don't frankly understand. He's voluntarily turned himself in twice in this matter in less than a month's time. And I know the court doesn't have any,
That's the fourth time you've told me that. I get it.
but it's a substantial bond modification. And
Ms. Lundy.
Thank you, Your Honor. If the defendant is released, will that be with a scram alcohol tether, be able to
Yes.
post a $50,000 bond? I'm so sorry, I didn't hear the court.
Yes,
Thank you.
it would be with a scram tether and intermediate supervision through community corrections. So what I'll do, in fairness to your client, counsel, because if those results are out there, you can get a document from him to get the results so that I can have the results, and I may consider something else regarding his bond, or I may not. But I'll give you a week to get that. I'll just adjourn this out 1 week to the 26th, and we can see what we can come up with. If I don't have any testing, I'm not changing.
Your Honor, can we schedule this matter for an exam?
Is all discovery complete?
Yes.
I didn't hear your answer.
Yes, it is. I believe it is.
People have their witnesses available in a second.
We'll try, Your Honor.
Preliminary examination in person, January 2nd, 2025 at 12 noon. That's before me.
Thank you. Your Honor, just one more item on this.
I'm sorry?
Sorry, I just had one more question regarding the DeHaze matter.
Sure.
Is the court? Did the
He's
court
not
say-
here anymore. He's been taken back, but go ahead.
Okay, procedurally, did the court say it would entertain a request for a bond or review the bond again upon presentment of some information regarding the testing?
I need to see that he's testing. You're
Okay.
telling me he was testing.
Right.
I don't see it.
Thank you. I'll see what I can come up with. Thank you.
It's always fun to watch Judge Simpson get mad. I don't think he's got a real good poker face, and I don't think he tries anymore. I think he wants people to know exactly how he's feeling about everything. I'm so glad to see Nan there. Nan, thank you for coming out. We can go on to the next one now. We got Judge Stevens. We got Judge Stevens getting on to somebody here, so let's.
And Ms. Murphy, raise your right hand. Do you solemnly swear or affirm any statement you make during these hearings today in these two cases will be the truth, the whole truth, and nothing but the truth, so help you God? Lower your hand. There's a first amended motion to revoke probation. I guess that's the most recent one filed.
Yes.
Here in 1187, I believe. Does the defendant waive a formal reading of this? Can we proceed in summary?
Yes, sir.
In summary, this states that on June 10th of this year, 2024, in this court, you were placed on 10 years deferred or unadjudicated probation for the third-degree felony of assault on a public servant. Is that true? The First Amendment. This allegation alleges that you committed the offense of assault on a public servant on or about August 13th, 2024 in Jefferson County, Texas. And that allegation is represented in this new indictment for CR 1985. I'm sorry, 1984. Do you understand that a knowing and voluntary plea of true to one or more violations of probation, that is enough to grant this motion to revoke probation by a preponderance of the evidence or greater? Your probation can be revoked. You can now be found guilty and sentenced up to the full range of punishment, which is no less than 2 nor more than 10 years confinement. Knowing that, do you insist on pleading true today? I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. There's an agreement that's been reached. It says the sentence shall run concurrently. That's all it says. What is?
It should be 10 years deferred probation.
She's already on.
Oh, I'm sorry. We're just sending her to safety. On the new case, she's being put on 10 years deferred probation to run concurrently with this MTRP. And we're placing her back on probation and sending her to safety.
This motion.
She did commit another assault on a public servant.
Yeah, let me go through it. And then, so thereafter, on August 13th of 2024, as she's admitted, she committed another assault on a public servant while she's on deferred or unadjudicated probation for the same thing. And we're not changing her status from deferred. How many free ones do they get?
Just this one.
No. The public servants are protected by me. When you assault them, it's like you slap me in the face. It has accountability. I'm not saying we need to put her in prison, but deferred is not going to be allowed anymore. She's lost that opportunity because what's good for one's good for all. But a public servant, again, the same kind of thing. You knew we made a big deal about it and that it was forbidden. So yet go back and do it. I'm not going to do that. Now, I like the safety idea and all, but it's going to have to maybe be evolved to a regular probation, maybe.
Excuse me.
Can it be?
And on the old case, it would just be safety and continue to defer on the old case.
Yeah, no, I'm not going to do that.
No, I'm talking on the old case.
The old case, she was placed on deferred and she's committed a crime while on deferred, an assaultive crime on a public servant. She doesn't stay on deferred.
So that would.
That's just not the way I do it. She knew she had been scolded the first time and yet went right back. And so y'all can come back to me later on that. Y'all, but that's not what I'm going to say. Okay. Thank you.
I can get with Ms. Scott and work something out.
Mr. Russ, let me ask you something. There's an indigent form here because you just don't get free lawyers when you get in trouble. You got to pay for your lawyers, or the taxpayers, if you're unable to, you're indigent, taxpayers have to pay, which they don't find that amusing when they work and they feel like people have to, just like them, when they get in trouble, they got to take care of their trouble. You're showing zero income. You have zero income? You don't, well, I mean, where did you get your clothes? Goodwill? Where do you live? Do you pay anything at all? Well, see, I had family members who had strokes and they were employed. I mean, how did you get here today? Okay, but you're ambling about. You can walk. You're interacting with me. You seem intelligent. Why aren't you getting a job? You just don't blame it on, everybody's got problems. You know, everybody's got a physical problem. You're not being, you're not being punished in any way. You know, we got good days and bad days, but all of us are imperfect. Why aren't you working somewhere? Because look at you. You look like you're healthy and you're smart.
Actually, I'm fixing to get my disability. I just got on Medicaid. I'm pretty bad off.
What do you mean you're bad off? You're ambling about and you're speaking coherently. What's your problem?
The car wreck I got into.
Okay. Who hadn't been in a car wreck, you know?
Hospitalized on frontline 3 times.
Sir? I know, but you're not on deathbed right now. Everybody's got problems, and sometimes people die or almost die, but they rebound. That's the way nature makes us. We're elastic almost. We can rebound. I don't understand. What are you doing about getting a job? Are you doing anything, or are you just going to take a free ride off the government money? Because I'm talking about, I have people who are paraplegics, and I can understand that. But you're ambling, you look healthy, you speak, what can't you do?
Can't be on my feet in 45 minutes.
I know there are jobs where you can sit. Look at me. I'm sitting down.
I'm literally waiting on my disability.
Is that you elected to become dependent? That's a choice.
I can't get back on the table. I can't work on table.
Why can't you work? I don't understand.
Because that's what I've done all my life. On table.
Well, you're gonna have to try something different that's you're able to do, but you want to be independent, don't you? Everybody, you have that. Okay. Well, I think you can be. So you had a setback. We all do. Pick yourself up, dust yourself off, and do the best you can with what you have to work with. But I don't understand why you're just saying, I gave up. I'm not going to work. Everybody else is going to pay my way. I don't look at it like that. Okay, good. But I need you to convince me that we're not going to pay your way through this. And have you ever been in criminal trouble before?
Yes, sir. When I was 19. 40.
Well, what happened at 19?
I got a head-on collision. And then 5 years work.
Oh, it was manslaughter? Person died? So you're not eligible for probation in front of a jury, is what you're saying. Is that right, Langston?
Yes, sir.
He's not eligible, but
Yes, sir.
But this is, he's eligible for deferred.
Would you?
Well, yes, yeah, juries don't give those.
But you can tell the judge yourself, because
No, y'all talk about it, but on the, and hey, if he needs a trial on it, if he's contesting it, that's his right. We defend that. What's the loss on this? Is there a loss?
Yes, sir.
Which one is this, Your Honor?
I'm sorry, this is Mr. Rutz.
Right. That's a missed the point.
Again, I'm sure.
Megan, what you need to do is you gotta.
I'll go ahead and jump in there. Karen, deferred is, let's say you get in trouble for stealing something and the judge says, we're going to defer your sentence, meaning if you follow all the rules in a year, it'll fall off and you don't have that on your record. So sometimes people get deferred sentences for some minor things, some pretty serious things, but most of the time it's kind of minor things, and they get deferred. Like if you do good for a year or 2 or 3 years, it'll come off. So it's a really good deal for first time offenders and people that are just made a mistake and just need some help on it. But one thing I wanted to mention on this, I guess this young attorney here in the black suit jacket, does he look 12 to you guys? At first I thought he was the defendant, but then the guy in the plaid shirt was talking as the defendant. So I can't figure out this other guy. I didn't know if he's an intern or what he is. So if y'all know what he is, let me know.
Yeah, I expect you to go out and try.
There was, I'm sorry, Your Honor. I'm sorry. There was none. The ATV was recovered on it.
Okay, there's no restitution on this one. I mean, this is one that's fixable, I think, but it's y'all's deal. If you're not guilty, you're not guilty. That's the way it is. And there are options that are available, but here, this zero across the board, David, is get out there and try. I expect you to try. I think you're capable of, independence and also making a better life, not only for yourself, but for others too. We'll do it. All right, I'm gonna give y'all 30 days, 4 weeks, okay? On this Langston, 44 weeks, okay?
That's fine. And I think I should
Come in and tell me where you are on this. Man, hey, Megan, I want to get someone make a note here. I want some proof of what you're doing to find employment.
Yes, sir.
Okay, with your circumstances.
Yes, sir. Hey, and Judge, on Miss Murphy, I did go and talk to Ms. Starr. If you don't mind, can you please give me 4 weeks?
You got it.
And I can make it happen.
Okay, so we're going to end that one there. So the guy in the gray suit is the defense attorney. The guy in the blue is the prosecutor. The guy in the black, we're going to call him an intern because he smiled way too much to be a defendant in that. So we're just going to say he's going to be an intern. So we're going to go there. But I'm right there with Metal Rabbit. I can't hear the defendant talking because the guy in the black jacket is in front of the microphone. I wish these judges and courts would really understand how important it is for us that we get to hear everything just right. Marty, there's a USA flag after your name because you're awesome. That's what that flag represents. So congratulations on that flag. Let's go to Judge Fleischer. Let's look over Judge Fleischer for a little bit.
Judge, I will let you know, Mr. McCollum did go down to pretrial services yesterday. They gave him a new monitor and a new charger. He's set to take his plea in January in his other case.
Come up, Mr. McCollum. Felicia.
Yes, Judge.
We ordered him to have a GPS monitor.
Yes, Judge.
We admonished you last time that there was absolutely zero tolerance. And now we have a third bond violation. What was the nature of this violation, please?
So it's that we lost cell on it, so either it wasn't charged properly or something of the nature, it's just.
So he had a dead battery.
Yes. And
How long?
I'm sorry. I'm sorry, Judge.
Take your time. I'm no rush.
If I may, if you would be willing to admonish the defendant as well. I spoke to the complainant yesterday and apparently the defendant has been making posts about her on social media, bribing people with money to hurt her, and she's pregnant with their child.
Judge, this complaining witness has been sending a bunch of messages to my client. She's been harassing him. I actually advised.
Show me.
I advised.
Show me.
I did ask her to send me screenshots and everything, Judge, and she said.
We'll have a hearing. Show me. We'll have a hearing. Show me what you got. We'll have a hearing over it. But all I know is this is your third bond violation. I'm not happy with you, Mr. McCollum.
Judge, I saw that I don't think it turned back on at all from what I'm seeing on my end. But whenever he did report yesterday to have the device inspected, and they did just tell me that he did receive a new charger and new device.
When did it die? What's the date?
14th.
So from the 14th to today, when he got it back on, it's been dead.
He got it on yesterday, Judge.
Yes.
But it was on
To
yesterday.
the 17th. It's been dead for 3 days.
Called me yesterday and told me to go to pretrial and check out, because they
Your
gave me.
device has been dead since December 14th. And
Aware of that, sir. I never knew they didn't give me no text or nothing. I was unaware. I'm thinking it's charging. They gave me a new
And
charger.
Judge, with all due respect, he went there on Monday. They gave him a new charger and a new device. So it seems to me that it's a technical issue. So Judge,
you're supposed to charge it on a daily basis. Am I?
Even in the pretrial, they charged it and they seen that it was charging, but it was still something messed up with the charger. So they gave me a whole new thing again.
How often is he supposed to charge it?
I think they're advised to charge once a day for at least an hour.
I'm not buying it. I'm sorry, Hunter. He goes with you. No. This is a third violation, Mr. McCollum. It's not going to continue to happen.
Judge, with all due respect,
Goes with you.
this is a technical violation. He shouldn't have to go into custody.
It's a third violation, Hunter.
Second, sir.
Judge,
Second.
it's
the first
clearly,
time.
just please stop talking. Let me talk. Judge, it's clearly that there was an equipment issue. Otherwise, they wouldn't have replaced the equipment. So I don't see how.
It'd be an excuse, Hunter. The minute you have an issue, you're supposed to go get it serviced, not 3 days later. This is a third stop. This is a third violation. And I told you the last time when you were here with the baby that there was absolutely no tolerance, that you were supposed to live to the conditions. 100, it's been dead for 3 days.
I was unaware of that, sir. So when they called me,
Goes with you. Sorry, I'm not going to entertain excuses. It's zero
I'm not
tolerance.
giving you an excuse, sir. They gave me a new charger and a new monitor. It's
Judge.
not like I didn't mess up anything. As soon as they called me, I
Come on, talk to your attorney. Judge, would you allow me to escort him up to felony court so that he can go take his plea today? The whole reason they had set the plea to after the holidays is so that he could do it after the holidays. And I believe part of this deal would see this case go away, and he's gonna be on probation for 2 years upstairs. So I really don't see the benefit to
I
society.
mean, if you want to go see if that's something that you guys can work upstairs, I can ask if they'll escort him upstairs. But I can't continue to play this game, Hunter.
I understand,
You know,
Judge.
I mean, really, we ask you over and over and over to comply. I'm not asking for much, right?
understand,
And
Judge.
it's been dead for 3 days. You know it's been dead because you're supposed to charge it. So you're supposed to charge it on a daily basis. So for you to come here and tell me I didn't know, it's disingenuous. It's just not true. So, but
My
I'm happy
frustration as
to
a
acquiesce.
attorney is I've seen this with multiple clients where there are technical issues that happen with these devices. I've seen it with multiple clients where they're unable to
Hey,
charge.
if you see it on the 14th that you have issues, then you go immediately. You don't wait 3 to 4 days later, especially when you've had violation after violation after violation. I think that your complaining witness may be here too. Rosette, CW may be here as well.
Judge, I'm not sure.
So I don't know, Hunter,
I
just,
believe that's for a judge.
okay, ma'am, please don't. If you want to,
I think pretrial has something to say. I don't know what they have to say.
I reached out to my supervisor of these devices just because I'm not super well versed in the GPS realm, but he stated that the reports for his GPS appear to show an issue with overcharging, which can lead to a charger problem. They're instructed to charge for 1 full hour on the same time each day, and that the tech swapped his device as a precaution as it was likely that malfunctioning.
but why wait 3 days? You know the device is malfunctioning on the 14th. You're going to wait 3 days to go get it fixed?
I was just informing of what my supervisor told me because I asked somebody to look over the report.
I don't know what to tell you,
I
Hunter.
mean, Judge,
You
it
know?
sounds like he was overcharging. He was doing more than required.
No, we don't know that for sure. I don't know. See what documents that you can show me, that you can get that there's some kind of malfunction. But nevertheless, it's a third violation. On the 14th, if he has issues, perhaps even go the next day on the 15th. But you wait 3 days, and the only reason he did it is because I hauled him into court and I told him to be here on the 18th. Otherwise, who knows what would have happened? See what you can find and then show me. I'm all eyes.
Well, Judge, the other thing I would ask is if you are gonna take him into custody, I'd ask for a formal hearing to be set. And since this was set within less than 24 hours, I do believe it violates his due process to go ahead and take him into custody today. Yeah,
Just show me what you can find, Hunter. You know, Eddie.
Judge, real quick, Judge.
Right. Okay. Get what records you can, show me something.
Okay.
Eddie. Guys, are you ready?
Yes, Judge.
There are times in life when you run into people, they can be a complete cancer to your life. Some people thrive on drama. That's how they get off. That's all they like. They like to just create. If you have people in your life like that, it's probably advisable to cut ties, because if not, they're just going to bring you down. We all have people like that in our life. We do. I do. I have people that are constantly after me as well. I do everything in my power to get away so that it doesn't bring you down. The problem is, Mr. McCollum, is when we have situations where there are repeated bond violations, I take issue with that. And I can't let people go when they continue to have violations. But I want to know that it's a true violation. I have ordered him not to have contact with this person, correct? I'm not asking much from you. The only thing I'm asking you to do is stay out of trouble, keep your monitor on, and don't have contact. Stop. I'm not asking you to say, I don't like to put people in jail, but I got to know that you're complying with the conditions. There's a lot of things that are at play in your case here. There's a lot of other evidence that's out there that I would like to see before I take action and put you in. They're saying things that happen. Hunter is saying things that happen. I want to know what the truth is. And the truth is, and it lies with the evidence, because the evidence will point to whose side is correct. Words, Mr. McCollum, words mean absolutely nothing. I don't give a rat's ass about words. Evidence points to whose side is correct. I am going to give you some time, not a lot, but I'm giving you to Friday to figure out what's going on, because I want to know. Most importantly, is it the machine that's messing up? Are you truly charging it? Number one. Number two, they're saying that there's been contact. I hope not. I want to know. I want to see it. Show me what you have. Likewise, show me what you have too. I'm all ears. I'm giving you the benefit of the doubt right now. If I wasn't, I would lock your butt up right now. But I'm giving you the opportunity now to show me what evidence is out there. Show me what you're doing. I want to know, are you charging this device as it should be? There are records of this. You know what the expectation is. I'm giving you time, Mr. McCollum, and I'm giving you the opportunity. I want to see it. Likewise, I want to see in what validation they have as well. That's it. We will reconvene here Friday because I want to know what Hunter has. I want to know what they have. Is that enough time?
Yes, Judge. Friday's fine.
You have any questions? You know what? It's better not that you don't. If you have any questions, talk to Hunter. But I'm giving you the opportunity. All I want to know is, are you abide by it? Are you abiding? That's all I want to know. Okay. See you Friday.
And Katie is here as well.
Hey, so you guys are going to have to help me. Today's Friday. Did he come in today? It seemed like Judge Fleischer wasn't on but like 10 minutes today. So yeah, let's see, Critter, Judge Fleischer was in, but it was on just a couple hours. It seems almost like some of it got cut off. I didn't get to see it all, but there wasn't much to today. It seemed like he was getting ready for the holidays. We're gonna have to see somebody who's paying attention today. But I'm curious if that guy came in. I'm curious what. Yep, Gina said no. I don't think. Didn't watch too much downtime a bit. Yep. So I guess we're never going to see that guy come in on Friday. So maybe next week he'll be in. Yep. 20 minutes worth of stuff. Yep, absolutely. Whenever I looked at it this afternoon, it wasn't much. I was driving home, so I didn't get to see much. Speaking of which, it's cold. It's getting cold tonight in the southeast, so make sure you guys stay warm. I'm sure the really cold areas are laughing at us, but it's cold.
Zoom to approach for this stuff.
Who's here?
Yes, Judge.
Oh, hey.
Hi,
Do I know
Judge.
you?
Let's see if I can get my video on.
Do I know you? So tell me about Mr. Nguyen. Number one, is that spelled correctly? There's usually a Y-E-N.
That's what I was thinking too, but that's what they put in the confirmation too, I think, so.
What would you, do you want something?
Yes, Judge, we wanted a bond on him, I believe, it's a 1997 warrant, so I'm a bit.
He's here if we want to bring
He is
him
in
in.
the back.
Please.
So, I did want to see, I asked him to agree on the bond, they are not because of his criminal history. He's got criminal history that dates 20 years back. I don't believe he's got anything current as of 10 years. So this is a warrant out of New York.
Yes.
30-year-old warrant, so.
He's literally he's been on, that the warrant is truly 30 years old, really? Is that old?
1997.
Yes, Judge.
What,
Great.
from him?
No, from, I believe. Shh. Something.
Wow. So it's a burglary, it's an assault, it's a robbery, and a possession of a weapon. Okay, I guess let's talk to him when he comes out, you know?
1997 New York, Judge.
Is that what was happening in 97? I thought New York was dangerous, but shit. Do you want to do a name change, Katie, or no?
I don't want to.
For the fugitive case, Judge?
No.
It's spelled Nguyen, and there's always an E.
I don't think we would need one for the fugitive case.
Okay, I don't know. I'm just,
I can look at the warrant and double check.
good morning, Mr. Nguyen.
Morning, sir.
Mr. Nguyen, you're wanted out of the state of New York for a host of charges, specifically for a burglary, an assault, a robbery, and a possession of a weapon.
He didn't parole. He was out on parole about 10 years ago on these cases, so once again, we're not sure.
Wait. That may change things. If he's out on parole, then, hold on.
I'm sorry.
It's okay. But if he's out on parole, Katie, there may be a pre-signed waiver.
He completed.
Judge, let me check. I'm not seeing that we have a pre-signed waiver,
Have you,
but I think that, Amy, you had some contact with the jurisdiction?
Yeah, so Manhattan County reached out to us this morning. They were asking if we had the waiver or a refusal for him yet. They didn't indicate to me whether this was a probation or a parole. I can reach back out to them to see. Yeah,
That's really important.
I'll do that.
He couldn't have completed because there's a warrant. There would be no warrant if he completed parole.
In as much as.
Something must have happened, Mr. Nguyen.
Can I say something now?
But don't talk about the case in general, but just,
Can I say something?
there's a warrant for a reason.
Can I say something, please?
Of course.
I used to live in Brooklyn. I committed crime and I lose, when I'm 16, 17, I don't speak English that much, so they send to me whatever they send to me. They send me to Rock Island, and they send me to upstate, and they charge say like burglary, armed robbery, some kind of stuff like that. But I do not speak English that much at that time because I came United States when I'm 14, and 5 years later I got arrested. So I basically understand a little bit, not that much. So when I go to court, they just do whatever they want to do. They don't tell me nothing. The case, they just say you got arrested, you got robbery, burglary, something like that. But I do not understand like that right now. So basically, after I finish, after they tell me that, they send me Rock Island. Or Rock Island, they send me upstate. So I do 5 years. First, I do 5 years.
Okay.
And I see parole.
Okay.
Parole, give me 2 more years. And I finished 7 years, and I went home. And then I went home. I do first. I went to live in Long Island first, and then I still go see parole in New York, right? And then my parents live in Houston, Texas, so I asked for transfer, my paper in transfer to Houston, Texas.
Okay.
So I've complete my parole, everything, and the opening. What year?
No. So you may have tried to transfer it. Perhaps it never transferred and you just came down here and never
No.
finished the transfer. I don't know.
No, I'm not the people do for me. That's why I'm allowed to transfer to.
Yeah,
Maybe there's an issue with.
there has to be some kind of issue.
Yes, that's what I'm saying.
I don't think we have enough information to do anything right now. What I need for them to do is reach out back to New York to figure out why the warrant was issued. Is it a parole violation?
I got parole violation one time. I went home, I worked, and I got violation one time. I went to work and they picked me up of what's that? Angleton. I went back over there, and I stand right in front of the judge. The judge said, "What you do? Why you do parole?" I said, "I'm working." So he said, "So show me your work." So I work. I bring all my paper, tax paper. I showed him. So he No. Can I say something?
Yeah. Go ahead.
He sent me to immigration. Immigration. They're coming out. I still do parole. I still finish. I have the letter over there.
Let's do this. Let's do this.
Yeah.
I'd like to roll it.
But no, that's too sorry. That's too sorry.
I get you. We just need them to.
So let's do this.
Yes, sir.
I'm gonna roll it to tomorrow because it's already nearly 12 o'clock. I want to give them time to look into it, to see what New York has to say. A lot of times when you get on parole, you sign a document that's a pre-signed waiver, meaning that you already agreed to waive extradition if this happens. We need to know if that has happened and if you have signed that, because if you have, I cannot give you a bond. Even if I wanted to give you a bond, I cannot give you one because there's a waiver that's already been signed.
What does that mean, waive, sir?
I'll let Ms. Oko explain that to you in back because I got a lot of people waiting.
Yes, sir.
But regardless, I'm not ready to do anything today.
Yes, sir.
I need more information from the prosecutors.
Can I say last thing before I go?
Sure.
What I do is, what happened is I finished parole, everything. I get the letter from Albany, say I'm complete to Albany State in New York. That all the paper go to Albany.
So, but something must have happened.
We need to figure it out.
Yes, I got the letter, everything. They send me a letter, everything.
And Judge, I would just add that, I mean, at least from what I'm seeing when I run him, which I'm a little hesitant, but like there's like multiple states with like criminal histories that's like very extensive, that's more than just New York. And so we would also have to try to like
Okay, I
Like,
guess
figure
just
it
take your time, find out, and then we'll regroup tomorrow.
Get all his signatures for 20 years back. There's nothing going.
I get it, but I just want to know if there's a pre-signed waiver. We'll see you tomorrow.
All right, thanks, sir.
Okay, of course, Mr. Wayne. Please. All right, thank you, Amy. Colin. Of course.
All right, that's it for the Judge Fleischer. I'm gonna throw in one with Judge Shackelford. It's about 10 minutes, and then we're gonna call it night. So here's Judge Shackelford.
All right, to the allegation you failed to appear for your appointment with the probation officer is scheduled at 8 a.m. on December 18th, how do you plead?
Guilty.
To the allegation you failed to attend individual therapy at the Guidance Center is scheduled on 12/12, how do you plead?
Guilty.
And then we're doing a not, and to the allegation you failed to attend your individual therapy on 12/13, how do you plead?
Not guilty.
All right. All right, I'm going to accept the 2 guilty pleas as knowing and voluntarily given. All right, so I saw you, Abigail, on the 10th. And on the 10th, I let you turn yourself in for a day next door. I let you turn yourself in because I care more about your job than you do. So then, the day after that, I do this on Tuesday, you miss your guidance, your therapy appointment on Thursday, and then you miss your appointment with Kara yesterday. And it's like I don't know what you were thinking. Abigail, we've had trouble with you since you came in. It's not use violations. Oh, are you shocked by this? Are you surprised? Well, you should not be. You have consistently, if I count your violations, like I know that we're on number 7, but if you look at them, number 7's 3. Number 6 was 1, 2, 3, 4, right? I mean, it's like Kara's bunching them because it makes sense when you have that many violations in a short period of time. But you're consistently, you think this is Abigail's treatment court, and it's not. Yes, you do. It's a 23rd District Court treatment court program, and you're not special. You're not special in this program. Everyone else has to show up and they have to do what they have to do to survive, but not Abigail. Abigail can cancel her appointments as she sees fit. She can miss things, and it's a consistent pattern. And the response that we always get from you is like, well, I have a job. Well, your recovery is more important than your job. Because if you're sitting in Wayne County Jail, quite frankly, Abigail, on this, it should have been charged as a 3rd, and you should have a felony right now. Because let's talk about your record for a minute. You've had 3 drunk drivings in how long?
Within a couple of years.
Right? When was your first one?
February of 2023.
Okay. When was your second one?
December last year.
Of 23?
Yes.
Okay. Oh my gosh. When was your 3rd?
April.
April of 24. 3 drunk drivings in a year? Less than a year? Am I bad at math?
Oh, just over a year.
Just over a year, 3 drunk drivings. How old are you?
23.
Your last drunk driving, Abigail, you drove the wrong way on which freeway? Which one?
75.
75, we are miles out of Detroit. One of the busiest freeways in the state of Michigan, and one of the busiest areas in the state of Michigan. And you drove the wrong way on the freeway. That's how drunk you were.
I understand, Your Honor.
Okay, well, we're going over it because I don't think you do. I genuinely do not think you understand. And then you wouldn't stop for the cops. And a cop had to tap your car to get you to stop and get you from killing someone else or killing yourself at 23 years old, your 3rd one in just over a year. And you got a gift. One, you got your life. You're not dead. You're not in prison for killing someone else, which is a miracle, going the wrong way on one of the busiest freeways, probably in the country. We're the Motor City, and you're driving the wrong way on one of the busiest freeways outside of Detroit. Then you get the benefit somehow of, instead of having a felony, you get the benefit of getting a misdemeanor for this. And in exchange, you have to do a treatment court program. That's the thing. And you should have been doing prison time. You should have been, or at least significant jail time. And you were given a gift and you have squandered it. I have watched you since you come into this program. You think you're better than the other women in the program. It's clear to me. You think that, well, I'm going to start sponsoring someone, and you have all this time for all of these other activities. You don't have time to show up and do the things you have to do to stay out of jail. And I've had it. You're about to get the wake-up call of your life, Abigail. I'm talking. I'm about to give you the wake-up call of your life, okay? Because have you ever been to Wayne County Jail?
No.
Okay, you're about to go in just about 3 minutes. But let me tell you something. I have been to Wayne County Jail. I've been to Wayne County Jail a lot. I was there when I was a defense attorney, and I was there when I was a prosecutor. And it is not a nice place. It is not a pleasant place. And me giving you a day next door is not teaching you anything. I need you to understand you are looking at months in jail. Months. And quite frankly, even at their new facility, probably one of the grossest jails I've ever been in. And with people who are sitting in jail, awaiting trial or sentencing on pretty significant crimes. And you'll probably think you're better than them. And you're not, Abigail, because that's where you should be. So you are getting the wake-up call of your life. You're going to sit down in the Wayne County Jail. What's your rec?
3 days.
5 days. You're doing 5 days in the Wayne County Jail. You got nothing else to do? Forget your job, forget everything else, Abigail. I want you to understand this. I want you to really reflect on the next 5 days. I want you to sit there and think, is that the life you want? Or do you want to comply? I'm talking. You can either comply with this program and get it together, or you can go do your 90. It makes no difference to me. I'd prefer you be here. I prefer you get the help you need, because whether you realize it or not, you have a problem, and you belong in this program more than a lot of the other women that are here. Because what you have done on these 3 offenses is abysmal. It's terrifying. You're doing your 5 days at the Wayne County Jail. I'm writing no early release. You're gonna really reflect. You'll be out for Christmas. My gut tells me to give you 7, and I don't know that you deserve that yet. You're going in right now. You'll get out in 5 days. No early release.
I can't explain the.
No, I don't need it. I don't care what you want. Okay, go ahead, Al. Go ahead. Let's see if we can get you up to 7 days. Tell me what you got.
I mean, if it's not gonna matter, it doesn't.
Does my face look like it's going to matter?
No, it really doesn't. I had a lot of really nice things to say about the program. I really appreciate being here. I understand that what I did is absolutely horrible. I feel awful about it every single day. I'm haunted by it, honestly.
You should be.
And I feel really, really grateful to be in this program and to have the opportunity to work towards a better life versus just incarceration. And I feel really grateful for treatment.
Well, show up and do the program or go sit in jail. That's your option.
I was
And when you
throwing
come
up
back-
all week. I haven't eaten in 6 days.
Abigail.
That's why I missed on Wednesday.
Abigail, listen to me.
I'm going through an epilepsy diagnosis. I'm having seizures in my sleep. I slept through a therapy appointment, and I have a text from Josh that says any day that we need Zoom, we can use it. And then I showed up. And then he told me that we couldn't use it. It was a misunderstanding, miscommunication on his part or mine. I don't know, but I genuinely, I took everything into account the last time I was in front of you, and I took.
And then you immediately missed another appointment and you're, I'm done. I don't want to hear anything else. I'll mark your file medical, enjoy your 5 days in the Wayne County Jail. When you come back, you can tell me whether you want to be here or whether you want to give your spot up for someone who's earned it.
There's a hearing date for the.
I don't care about the other violation, dismiss it. All right, come on up. Ms. Heiss, I need you real quick at the podium. I need to give you your appeal rights. All right, Ms. Heiss, I did not give you your appeal rights, and I want to make sure you know them. An appeal to
So that lady got in so much trouble. I want to make sure anybody that's named Abigail changes their name so they don't get caught up in her mess. She mentioned Marty saying she mentions the possibility of epilepsy, but still drinks and drives. Yeah, that lady that's a weapon on the road. She don't need a license anyways. I didn't know you could get a license with epilepsy. Maybe it's you have to be so long without a seizure, but yeah, she definitely don't need to be driving. Yep, she don't need to be drinking or driving, and definitely don't need to be anywhere near me. So this is in Michigan. Donald, watch out for her. Find out what type of car she's in. I want to thank everybody for coming out. It's been a great. It's been really humbling this week. Fozzie, you couldn't be more perfect with the comment there. I've missed you guys. I've missed streaming. I'm trying to get it figured out. My work is kind of chaotic right now, but we're going to get it all figured out. Thank you so much for coming out. We really do appreciate the community. It's great. A lot of people are on Discord. A lot of people are talking on Discord. It's fun over there. If you have a hard time with Discord, go to Court Vibes' YouTube channel and look in the comments and the descriptions. It's going to be about the safest place to go. It's going to be the quickest place to get to the most people at the same time. You can always reach out with somebody and they'll help you with it. But thank you guys so much for for coming out, and y'all have a good Christmas. Me and Allie's going to stream some this weekend. I'll do some more streaming this weekend, and we're going to try to keep it busy next week. Most courts are going to be out, but in all reality, I haven't streamed enough. I've got plenty of court built up. I've got plenty of stuff come up, and we will certainly put it out there. I got to say hey to Kathy. Thank you so much for checking in, Kathy. I saw you at the beginning, but you was busy. Hopefully it got a little slower for you, but you guys have a great night, and we'll see y'all tomorrow a few times. Talk to you later. Bye.